At this precise moment, while you are sitting here watching this, federal immigration enforcement officers are conducting what amounts to the most extensive operation targeting Asian immigrants that this country has witnessed in the modern era. During the period spanning January through October of 2025, ICE took into custody 7,352 individuals originating from Asian and Pacific Islander nations. That figure stands at roughly 4 times the level recorded during the corresponding months under the prior administration when total apprehensions reached 1,998. And within that group of 7,152 people taken into custody, an overwhelming proportion, specifically 7,069, were formally placed in detention, while 2,631 were ultimately deported from the country. But here is the element of this situation that ought to genuinely shake you. A full 69% of those individuals who were apprehended while attending scheduled immigration appointments possessed absolutely zero criminal history. Not a single offense. These were people who presented themselves at their designated meetings, complied with every procedural requirement, and found themselves leaving in restraints. In this presentation, we are going to examine in detail the 7 Asian nations whose citizens appear to be facing the most aggressive deportation enforcement efforts heading into 2026. And what matters even more, we are going to outline the specific measures you and your household members should be implementing right now to shield yourselves from what is happening. Please stay with us all the way through because the 6th country we discuss is the one that has received almost no public attention whatsoever. Welcome. If this is your first time here, this channel is dedicated to delivering substantiated, verified information on immigration policy developments. We do not amplify fear beyond what the facts warrant, and we do not dilute hard realities to make them more palatable. We simply present what you genuinely need to understand in order to protect your future in this country. If this content resonates with you and proves useful, we would sincerely appreciate it if you would press the subscribe button, activate the notification bell, and pass this video along to somebody in your circle who needs to see it. That single gesture of sharing could truly transform someone's circumstances. Let us dive in. The first country on our list is Bangladesh. If you carry Bangladeshi citizenship and are currently residing within the borders of the United States, the terrain beneath your feet has fundamentally transformed over these recent months in ways that are nothing short of dramatic. Let us walk through precisely what has transpired. On the 6th of January 2026, the current administration officially placed Bangladesh on the list of countries subject to visa bond requirements. What this means in real terms is that any citizen of Bangladesh who applies for a B1 or B2 visitor visa to enter the United States could now be compelled to put up a financial bond reaching as much as $15,000 before they are even cleared to board their aircraft. The publicly offered rationale for this measure centers on overstay statistics. The DHS Fiscal Year 2024 Entry-Exit Overstay Report documented that Bangladesh carried a B1-B2 overstay rate hovering around 5.73%, a figure that corresponds to more than 2,200 separate instances of individuals remaining past their authorized period. Yet the enforcement measures did not conclude with the implementation of the bond. On January 21, 2026, the State Department enacted a comprehensive freeze on all immigrant visa processing for nationals of 75 different countries, and Bangladesh was included in that group. The tangible consequence is that family-sponsored immigrant visas, diversity lottery visas, and employment-based immigrant visas are all completely suspended. Anyone who had a scheduled interview at the American Embassy located in Dhaka saw that appointment either outright canceled or deferred with no definitive rescheduling horizon. What explains Bangladesh being specifically singled out for intensified removal enforcement? The answer involves 3 interconnected factors. The first is that the overstay statistics furnish the administration with a quantifiable data point they can reference in public discourse to justify their actions. The second is that Bangladesh falls squarely within the scope of the enhanced vetting protocol that USCIS formally announced on March 30th, 2026, a framework that now incorporates obligatory social media examination, review of financial histories, and verification through consular databases. The third factor, and this one carries exceptional significance, is that Bangladesh has been flagged as a country where unauthorized employment represents a mounting area of concern. A substantial number of Bangladeshi nationals who originally entered on academic or tourist visas have been discovered to be engaged in employment without holding proper work authorization. The administration has been deploying targeted workplace compliance audits and employer I-9 verification inspections as tools to locate and apprehend those individuals. If you hold Bangladeshi nationality and currently have any category of immigration matter under review, here are the immediate actions you should be taking. The first is to file a Freedom of Information Act request to secure your full immigration case file. You absolutely must review the complete contents of what USCIS has documented about you before that information potentially gets deployed against you during proceedings. The second is to engage an immigration attorney without any further postponement, not at some vague future point, not when your schedule opens up, but immediately, today. The third is to refuse to set foot in any USCIS appointment unless your attorney is physically accompanying you and present in that room. The period during which you could simply appear by yourself, armed with a folder of documents and trust that the process would treat you fairly, has reached its definitive conclusion. The second country is Nepal. Nepal occupies an extraordinarily precarious position at this juncture, and the unfortunate reality is that the majority of Nepali families living in America have not yet grasped the full magnitude of the vulnerability they currently face. During the summer of 2025, the head of the Department of Homeland Security formally declared the end of temporary protected status coverage for Nepal. TPS had been maintained for an extended duration, serving as a protective umbrella for thousands of Nepali citizens who were unable to return to their homeland safely in the aftermath of catastrophic seismic events and persistent conditions of instability. That protective coverage was officially dissolved as of August 5, 2025. A determined group of impacted immigrants undertook legal action to challenge this decision. A federal judge presiding in the Northern District of California entered an order seeking to halt the termination from moving forward. However, on February 9, 2026, the Ninth Circuit Court of Appeals vacated that lower court order, thereby permitting the government to proceed with eliminating TPS protections while the broader appellate process continued. The result is that at this current moment in April 2026, there exists no functioning TPS shield for citizens of Nepal. What does this translate to in concrete everyday terms? It means that each and every Nepali individual who had been relying upon TPS as the basis for their employment authorization and their insulation from deportation now finds themselves without that foundation. Their work permits have either already lapsed or stand on the verge of doing so. They lack legal authorization to be employed anywhere, and they now carry the classification of being subject to removal from the country. The scale of impact is considerable. Thousands of Nepali households are caught in this predicament, and a substantial number of them represent families with blended immigration statuses, scenarios in which perhaps one parent held TPS status while their sons or daughters are birthright American citizens. The current administration has made clear through its actions that it is prepared to break apart these family units. Layered on top of the TPS elimination, Nepal additionally appears on the catalog of 75 nations affected by the immigrant visa processing suspension. Therefore, if you harbored expectations of bringing a relative from Nepal to the United States through a family-based sponsorship petition, that entire avenue has been shut down. If you are of Nepali origin and your TPS has reached its end, you need to investigate every conceivable alternative legal route with genuine urgency. Engage your attorney in discussions about asylum eligibility, about pursuing adjustment of status if you have a qualifying American citizen spouse or child, about the possibility of U visa relief if you have been the victim of a qualifying criminal offense. Do not allow time to pass without action. Every single day of inaction brings you measurably closer to the possibility of enforcement officers arriving at your residence. The third country is Myanmar, which carries the alternate designation of Burma. Myanmar currently stands as one of the most profoundly tragic narratives within the entire landscape of American immigration policy. This nation has existed in a state of active armed civil conflict, continuously since the military overthrew the civilian government in February of 2021. The governing military apparatus has conducted aerial bombing campaigns against civilian communities, forced enormous population displacements, and perpetrated well-documented and systematic abuses of fundamental human rights. By every credible and impartial standard of measurement, Myanmar ranks among the most hazardous destinations anywhere on the planet for individuals being involuntarily returned. In spite of these dire conditions, on November 25, 2025, DHS published its declaration that TPS for Burma would be terminated, with that termination becoming operative on January 26, 2026. Approximately 4,000 Burmese nationals who had established their lives in the United States found their protective status suddenly stripped away without recourse. A federal court situated in the Northern District of California did intervene in the proceedings. On January 23, 2026, with just 3 days remaining before the termination was scheduled to go into effect, the court entered a temporary protective directive. But this judicial confrontation remains profoundly unresolved. The government has pursued its appeal of that directive, and based on the most recently available information from March 2026, the entire matter continues to hover in a zone of deep legal ambiguity. USCIS has published official guidance communicating that the TPS classification and its corresponding benefits have been ended, while simultaneously advising affected individuals to remain vigilant for any fresh court orders that might alter the situation. Here is what sets Myanmar apart from every single other nation we are examining today. The circumstances here have nothing to do with visa overstays. They have nothing to do with people working without proper authorization. The overwhelming preponderance of Burmese TPS recipients arrived on American shores through entirely legitimate refugee resettlement programs and recognized humanitarian admission channels. A great many of them are members of the Karen, Chin, Rohingya, and other distinct ethnic communities who confront documented and continuing persecution in their country of origin. Compelling these individuals to return is not simply a dry question of legal procedure. It represents a crisis of human rights in the most fundamental sense. If you are a citizen of Myanmar, keeping yourself in consistent communication with legal advocacy organizations such as the International Refugee Assistance Project and the Asian Law Caucus is not merely advisable but absolutely critical. You must develop a thorough comprehension of the alternatives that may be available to you, which could potentially encompass submitting a new asylum application predicated on materially changed conditions in your home country, filing for withholding of removal protections, or seeking relief under the terms of the Convention Against Torture. Do not operate on the assumption that a temporary court directive guarantees your ongoing safety. The judicial landscape possesses the capacity to shift fundamentally at any point and without advance warning. The fourth country is Cambodia. The Cambodian story constitutes one of the most long-standing and deeply painful chapters in the entire history of Asian immigration to America, and all available evidence suggests that this chapter is on the cusp of becoming substantially more distressing. Let us establish the essential historical context. Throughout the Khmer Rouge genocide and the cascading armed conflicts that devastated the region throughout the 1970s and into the 1980s, hundreds of thousands of Cambodian people fled their homeland and found refuge in the United States. A significant portion of them arrived as young children. They spent their formative years growing up in some of the most chronically underserved neighborhoods in the nation, communities spread across Long Beach, Lowell, Philadelphia, and the Bronx. A number of these individuals during their teenage years or their transition into young adulthood became enmeshed in the criminal justice system. They served out their full sentences. They met every obligation the law demanded of them. But because they had never completed the process of obtaining American citizenship, the courts imposed final orders directing their removal from the United States. For decade after decade, those deportation directives remained essentially unenforced and dormant. Cambodia had entered into a formal repatriation agreement with the United States, but the Cambodian government in practice consistently delayed and resisted the actual acceptance of individuals being sent back. At any given snapshot in time, well over 1,700 Cambodian nationals, bearing active final removal orders, were living ordinary lives within American communities. Many of them had been doing so for 15, 20, and in certain cases a quarter century or longer. That long-standing equilibrium has been decisively shattered. The current administration has exerted forceful diplomatic leverage on Cambodia to start receiving deportees in meaningful numbers, and it has commenced the actual execution of those orders that had gathered dust for years. In a development that sent shockwaves through the legal community, some Cambodian nationals have been sent not to Cambodia itself, but rather to entirely unrelated countries in distant parts of the globe. Recent investigative journalism brought to light the experience of individuals who were part of a group of 15 Cambodians transported to a correctional facility in Eswatini, the small kingdom in southern Africa that was formerly called Swaziland. These were human beings who had fully completed their American prison terms many years in the past and who had subsequently built constructive, community-rooted lives for themselves. Members of Congress have put forth legislative action in the form of the Southeast Asian Deportation Relief Act of 2026, but the prevailing dynamics in the current political environment mean that this proposed legislation faces a remarkably steep uphill battle before it could reach the point of becoming enacted law. If you are of Cambodian descent and carry a standing final removal order, or if you have personal knowledge of somebody in that exact predicament, making contact with the Asian Law Caucus, or CIRAC, at the earliest possible moment is of the utmost urgency. There is a live class action legal challenge currently underway that contests the deportation of Cambodian individuals operating under aged removal orders. You may well fall under the protective umbrella of this litigation, but that protection can only become accessible to you if you have established an active relationship with qualified legal advocates. The fifth country is Pakistan. Pakistan embodies a singular and progressively more perilous profile within the enforcement landscape. While public attention and media coverage tend to concentrate overwhelmingly on deportation operations involving Latin American and East Asian populations, the accelerating campaign directed at Pakistani citizens has been advancing with both remarkable discretion and considerable intensity. Let us look at the pertinent data points. Pakistan's B1, B2 visitor visa overstay rate currently registers at roughly 7.36% based on officially published DHS statistics, a percentage that surpasses the established average for nations outside the visa waiver program. The administration has leveraged this particular statistic to validate increased scrutiny, and active policy discussions are reportedly underway regarding the potential inclusion of Pakistan on the mandatory visa bond list. However, the enforcement focus reaches substantially beyond the overstay dimension alone. During September of 2025, DHS chose to publicly spotlight the apprehension of a Pakistani citizen who was taken into custody through a joint operation between ICE and USCIS, while the individual was attending what appeared to be a completely standard scheduled appointment in Tukwila, in the state of Washington. Government officials presented this particular arrest as a public demonstration of their stated mission to apprehend those they categorized as the most serious threats. The broader ripple effect of publicizing such a case, however, was to transmit an unmistakably alarming message to every person of Pakistani origin who has any upcoming USCIS meeting on their schedule. Pakistan likewise appears among the 75 nations encompassed by the immigrant visa processing moratorium, which in practice means that family-based immigration pathways connecting Pakistan to the United States have been rendered completely inoperative since January of 2026. Thousands upon thousands of Pakistani families who have patiently endured years of waiting, with some having sustained that wait for longer than a full decade to see their priority dates become current, now find themselves trapped in an indefinite holding pattern that carries no projected timeline for resolution whatsoever. On top of all this, the broadened USCIS vetting architecture places direct and pointed emphasis on the examination of social media conduct, and this particular dimension holds acutely heightened relevance for applicants originating from Pakistan. The administration has deployed what it has formally designated as Operation Paris, a comprehensive enhanced screening initiative that encompasses the systematic searching of social media profiles, detailed scrutiny of financial transaction records, and even the review of activity within encrypted messaging platforms. For communities in which WhatsApp serves as the foundational tool for daily interpersonal communication, this development generates an exceptionally significant window of vulnerability and exposure. If you hold Pakistani citizenship, Here is the guidance we would offer you. First, conduct an exhaustive examination of your entire digital and social media presence. Every individual Facebook publication, every message posted on X, every WhatsApp status update, any content whatsoever that carries even the remote possibility of being extracted from its intended context or utilized to your disadvantage should be carefully evaluated in partnership with your legal representative. Second, if your immigration history includes any periods of status expiration or intervals of employment without proper authorization, sit down with a qualified lawyer for a thorough consultation before you initiate any fresh application of any type. The act of submitting a new filing has the capacity to set in motion a comprehensive background review that brings previously buried complications to the surface. Third, maintain your emergency contact card on your physical person at all hours of the day and night, ensuring it contains your attorney's direct telephone number, the ICE detainee hotline reachable at 866-347-2023, and the address for the ICE detainee locator system at locator.dice.gov. The sixth country is Afghanistan. And this is the entry on our discussion that is perhaps the most emotionally devastating to address. A significant number of Afghan citizens currently present within the United States do not correspond in any way to the conventional image of undocumented immigrants. These are individuals who stood and worked directly alongside American military service members, embassy personnel, and intelligence professionals across the entire span of the two-decade military involvement in Afghanistan. They fulfilled vital functions as language interpreters, as logistical operations managers, as cultural bridge builders between forces and local populations. They personally assumed mortal risk in their commitment to serving American interests. When the Taliban seized governmental control once again in August of 2021, substantial numbers of these allied individuals were evacuated from the country under the umbrella of Operation Allies Welcome and were subsequently provided with temporary protected status. On May 12, 2025, the formal announcement came that TPS for Afghanistan would be terminated. That termination took operational effect on July 14, 2025. In that single administrative stroke, thousands of individuals who had been America's partners in wartime lost the entirety of their legal protection. Prominent international human rights organizations characterize this decision in the most severe terms available to them. Dedicated advocacy organizations that work specifically on behalf of Afghan wartime partners issued pointed warnings that this policy directly and immediately imperils the physical survival of allied individuals together with their entire extended family networks. Under the system of governance imposed by the Taliban, any individual who provided any form of cooperation or service to the American government confronts the genuine prospect of being imprisoned, subjected to systematic physical abuse, and potentially executed. Subsequently, the surrounding public discourse regarding Afghan immigrants descended into deeply troubling territory. Following an incident in late 2025 that involved an Afghan immigrant, inflammatory public commentary targeting Afghan communities and other immigrant populations was issued from the most senior levels of government. Language of this nature, emanating from the highest position of national authority, inflicts damage that extends far beyond emotional injury alone. It generates tangible physical danger for affected communities. It can serve to encourage enforcement personnel to adopt more confrontational postures in their operations. It degrades the wider public's perception of and attitude toward immigrant populations as a whole, and it creates conditions in which Afghan families find it effectively impossible to experience any genuine sense of personal safety, regardless of where they are within this nation's borders. As the situation stands in April of 2026, Afghan nationals possess no TPS coverage of any kind. The immigrant visa processing suspension encompasses Afghanistan fully and completely, and the country has been placed under the expanded travel restriction framework pursuant to the applicable presidential proclamation. Every conceivable pathway for legal entry or protection has been progressively constricted or entirely blocked. If you hold Afghan citizenship, pursuing an affirmative asylum claim should be regarded as your foremost legal strategy. The conditions prevailing inside Afghanistan under Taliban governance furnish what numerous legal scholars and practitioners consider to be among the most persuasive and well-documented foundations for asylum relief available anywhere in the world at this present moment. You need the advocacy of an experienced asylum practitioner who possesses intimate familiarity with the particular evidentiary requirements and documentation benchmarks that apply specifically to Afghan cases. Organizations including HIAS, the International Refugee Assistance Project, and groups specifically dedicated to supporting Afghan wartime partners can serve as bridges connecting you to qualified legal assistance. The seventh country is China. China commands the highest position on this list when evaluated purely by the volume of enforcement actions. Published analysis of official government data reveals that Chinese nationals comprised roughly 26% of the aggregate Asian ICE apprehensions documented between January and October of 2025, a figure that translates to approximately 1,991 discrete arrests. That proportion represents the largest share attributable to any single Asian nation, with Indian nationals following at approximately 25%. However, the character of the enforcement campaign directed at Chinese nationals differs fundamentally from the patterns observed with the other countries we have examined. This campaign is propelled in equal measure by the forces of international geopolitical calculation, as it is by the mechanics of domestic immigration enforcement policy. Early in 2025, the Chinese government communicated its readiness to accept the repatriation of verified Chinese citizens from American territory. Published reports indicated that this cooperative stance materialized following the application of economic pressure in the form of threatened trade penalties and tariff escalation. DHS subsequently initiated removal flights destined for China, building upon and expanding a logistical architecture that had its origins in late 2024, when the preceding administration oversaw the repatriation of more than 500 Chinese citizens and laid down the operational groundwork for systematized deportation. Air transport spanning the Pacific. Under the present administration, the tempo and frequency of these removal operations have escalated to a markedly higher level. Monitoring systems tracking ICE flight activity documented that, by February of 2026, domestic shuttle flights transporting detainees between holding facilities and removal staging locations were averaging 42 separate flights each day, an increase from the 39 daily average recorded during the month of January. A meaningful share of this domestic transport activity funnels directly into internationally bound removal flights, with China standing as one of the primary receiving destinations. The enforcement activity targeting Chinese nationals additionally intersects heavily with a framework of national security messaging. The administration has publicly cited apprehensions surrounding espionage operations, the unauthorized acquisition of proprietary technology, and what officials characterize as the strategic exploitation of immigration pathways by operatives allegedly acting on behalf of the Chinese government. While certain of these articulated concerns may carry genuine substance when applied to narrow, individually documented cases, the sweeping and undifferentiated manner of implementation has resulted in thousands of entirely ordinary Chinese families, encompassing restaurant industry employees, university students pursuing their educations, and owners of neighborhood businesses, being drawn into the enforcement apparatus. China additionally falls under the broadened travel restriction framework established by the pertinent presidential proclamations. It bears the full impact of the 75-nation immigrant visa processing freeze, and it has received a formal designation by ICE as a country deemed insufficiently cooperative in accepting the return of deported nationals, a characterization that the administration maintains notwithstanding the fact that Chinese authorities have made public statements affirming their willingness to accept returning citizens.